So here we are. I'm Juliet Kostritsky, obviously, and the title of my talk is Discriminating Alignment in the Innovation Sphere. The first thing I want to do is to thank some people who made the symposium possible, and they include my colleague Eric Chafee, Patty Harbold, Rob Coombs, who's sitting in the back, and Martin Raska, and they all are incredibly important. The other people that I'd like to thank start with three professors at the University of Wisconsin, where I went to law school. And really, I stand on the shoulders of Stuart McCauley, Bill Whitford, and Bob Gordon, all of whom have read drafts of mine over the years and been incredibly generous with their time and encouraged me to do empirical qualitative research. The other scholars that I'd like to thank are Matt Jennejohn, Lisa Bernstein, Josh Whitford, Liza Vertinsky, and Gerta Hessen. And there are just so many others that I've learned from. And before I start my talk, I want to talk about how important my research assistants were in the project, because doing interviews with people takes a lot of time. So I want to thank Alex Baru, Kate McClure, Virginia Lefevre, Sherry Javinis, Ben Crawford, Corey Wetzel, Anna Glavas, Lauren Malabar, and Ryan Mentor. And they've all been incredible. And then, because I interviewed people in the biopharma and innovation sphere, I want to thank the people who granted interviews with me, who really made this research possible. I guaranteed anonymity, but I was still amazed at the willingness of people to talk to me and share their insights. Most interviewees in the project were connected to someone I knew who referred me to someone else and so forth. And through 40 years of teaching law, I've gotten to know a lot of lawyers in the transactional field and a lot of general counsels, and they really helped me out. Okay, so I should be advancing the slides, which I haven't been doing. This is a slide which is too small, I know, but it shows you the people that I interviewed in the field. The categories were pharmaceutical general counsel, biotechnology general counsel, innovators, technology officers, law firm attorneys, retained counsel, academics, and alliance managers. And they all played an incredible part in the project. So, okay, I'm not a slide person. So anyway, so what we know so far, well, the de-verticalization of the supply chain. So in broad strokes, this is what we know. There's been a shift away from ownership when one firm controlled the economic production and made buy decisions for fungible goods. So now there are increased relationships with external firms. In more deeply collaborative relationships in both manufacturing and biopharma. Why? Well, because of competitive pressures and the need for knowledge, which is hard to produce internally. So there are lots of terms that are used to describe these relationships with external firms. Matt Jennejohn uses the term creative ordering. Hagedorn and Hessen use the term framework of governance. My goal is to unpack the way the governance works in practice based on information generated from interviews, studies from others like Helper, McDuffie, Jennejohn, and Bernstein. So I'm going to start talking about governance, and that's going to be a theme because my thesis is that there's discriminating alignment in choosing the type of governance that's going to play a part in either biopharma or manufacturing. So I want to highlight a few things. So one of them is that the contract itself may operate as the governance. And then other things come into play in governance. One is that there are private strategies that are non-contractual, such as pairing with another entity in which the patent overlap is not great. All of these are pieces of governance, hiding the secret sauce of the trade secrets until later in the relationship. And then formal and informal enforcement strategies. They're all part of this larger governance structure. So here's the puzzle. Contract is playing a much bigger role in these alliance agreements. But the traditional view had been that if there was a contract between a firm and another external firm, then holdup would play a huge role and subject the firm to extortion, as when an auto supplier such as GM might be held up by Fisher Body in supplying the doors. So as of course Sue Helper points out, this is a more complicated story than we first sort of speculated about. So the solution to this problem of holdup between external firms was, the traditional idea was, well, then you vertically integrate. Well, today, what has replaced vertical integration, and what roles do contract, property, formal and informal enforcement play at various stages of the relationship? We've shifted from vertical integration to relationships with external firms, and I'm interested in what has replaced vertical integration as the source of governing these relationships. So a few things to keep in mind is, well, that was the puzzle, and that was the role of contract, yeah, okay. I have to go back for one sec. So understanding contract and governance requires more than looking at a single contract provision. A clause such as information sharing, which has been a subject of a lot of scholarship by Gilson Sable Scott, may operate differently depending on which industry, what problems are need to be solved, and at what stage of the relationship. As one interviewee said, it's a piano and all the keys matter. And we're going to see how. Okay, so relationships between firms in the innovation sphere has prompted scholars to examine how parties use or don't use contracts. Do they put them in the drawer? What else do they use them for? So partly they're to govern and partly they're to enforce. Now, the role of contract has puzzled scholars ever since Stuart Macaulay suggested that contracts were rarely consulted in the buy-sell context among businesses he interviewed, but instead put in a drawer. Okay, so the durable problems that these firms face are, and the obstacles to solving them include the fact that contracts are necessarily incomplete. The problems remain, they include opportunism and shirking, holdup, and some newly identified problems that Matt has talked about, including entropy and spillover. So the governance solutions took different forms in different contexts. We had relational contracting in certain areas, like the diamond industry. We had reputational sanctions in medieval trade that Avner Grief talked about. We had modularity. And so I'm interested in what governance solution is applicable in a particular context. Okay, and so the first thing I'm going to talk about is, well, what's different in contracts involving manufacturing and biopharma? So in manufacturing, there's a presence of these detailed provisions that concern the processes by which the manufacturing process is monitored, or the production process is monitored. So there's a quality control handbook, and it details these processes. Often they're incorporated into a purchase order. And the goal is to have error detection, find out how many errors in the parts per million, to establish benchmarking, to have mandatory web training. Well, there is usually one quality handbook with all of these provisions that applies across the board to all suppliers. These are not individually negotiated contracts. And how are they enforced? As Lisa Bernstein has told us, by interior remedies in which suppliers who supply faulty goods are downgraded. Okay, so in biopharma, there may be innovation, obviously, in both these sectors. The contract provisions are central. They're not peripheral. But what does that really mean? Gilson Sable Scott suggests that a contract provision, such as information sharing, works to endogenize trust. Matt Jennejohn suggests that particular contract provisions, such as contractual lock-in, exist to control problems that have been unrecognized maybe so far, like spillover and entropy. Hadfield and Bozovic suggest that parties refer to the agreement as a how-to book for the alliance. Okay, so today we learned that context matters in other ways, that the internal organizational processes at a firm can affect how the contract provisions are implemented and whether they're going to be successful for an entity involved in an alliance. And that was Lisa's introduction. So even if a contract is central, and that's what we've been told about the biopharma industry, there's certainly a lot of contract provisions. And so I thought that parties were going to be able to tell us what provisions matter and at what a point in time and why. So the use of contract doesn't necessarily tell us what contract provisions matter the most. Well, what do parties say matter the most? And what I was told in interviews was that negotiating the IP division is the most important contract provision, and secondarily, the termination provisions. So context matters in terms of what use the contract provisions play and at what stage and how that's going to all tie into making the contract alliance successful. So the big picture conclusion that I have is that parties in biopharma choose a combination of contract as a form of governance, which includes incentives, often hidden in the SEC filing since we don't know what the numbers are for the incentive structure. And that applies during the discovery process. And then property provisions in the contract govern at the exit and at some other crucial points during the alliance, such as when there is a need for patent enforcement. So what this all tells me is that there are deliberate choices being made by the parties, and they reflect discriminating alignment in the governance. So let's just talk a little bit about what Oliver Williamson says here. And he defines this process of discriminating alignment as assigning transactions which differ in their attributes to governance structures, the adaptive capacities and associated costs of which differ in a discriminating way. And that's, of course, from his famous book, The Economic Institutions of Capitalism. And I want to just note here that everything I learned about Oliver Williamson, other than from reading all of his books and articles, is from my former colleague, Ron Coffey. This discriminating alignment thesis that I have for this area suggests that maybe there is a new private ordering going on. In a sense, when parties in biopharma choose elaborate committees to govern the discovery process, they do so to maximize the chances of success. That's what interviewees say. They also employ property provisions at the exit or nested options, or they choose to revert authority to one party in a dispute who has the relevant expertise to help ensure success. So they are, in effect, through their contract, engaged in a private ordering mechanism in which they use committees and shared control and joint incentives at the discovery stage and property provisions when the interests are no longer aligned. Okay, so well, what is this relationship of discriminating alignment, or the thesis here, to other scholars working today? Bernstein raises the importance of informal internal organization and its effect on the alliance success, and the importance of interior remedies. Jennejohn emphasizes the importance of state intervention through industrial policy. And I'm emphasizing today that the parties themselves are structuring deals calling for state intervention at exit when property provisions come into play and informal enforcement is no longer a workable strategy. So I want to talk a little bit about informal sanctions and informal enforcement. First, just sort of background about what that means, and then switch to looking at it in the context of biopharma. So when do informal sanctions work, or what have people told us who've written about this told us? So there are certain preconditions for informal enforcement working, one of which is repeat play and the ability to threaten a counterparty with reputational sanctions. Repeat play may not actually occur in biopharma. There may be a long-term relationship, but it's not a repeating relationship. Okay, so informal enforcement in manufacturing is well documented by Bernstein and Peterson in their recent article. The defaults of the parties in that sector prompt interior remedies exercised by those parties. Now, informal enforcement plays a much smaller role in biopharma, though that itself is a complicated story that I really began to learn about once I started interviewing people in that sector. So essentially, the contract provisions in manufacturing and R&D are doing different work in different sectors. So, all right, so we know in some communities informal sanctions work, the diamond bourse, or medieval trading communities where bilateral sanctions against traders who defaulted were extremely effective. So why is informal enforcement different in biopharma, or what I learned from these interviews? One of the things that I learned is that there are constraints on using informal enforcement to informally sanction innovators. So why would that be? Well, the responses were that such sanctions might interfere with the innovation process. Another interviewee suggested that informally sanctioning an innovator could signal a problem with the project. And biopharma does not want information of a hiccup in the innovation process to surface, as that would negatively affect their reputation and the ability of people to say, oh, this is a successful discovery, this is a great new drug. Also, interviewees suggested that they didn't want to sanction innovators because of the need to attract innovators in the future. They need to keep the pipeline of ideas coming. So, in fact, one interviewee expressed absolute shock when I suggested the idea of informal sanctions against innovators. Okay, so that was a wake-up call for me. So why else might informal enforcement be problematic? And this, this topic started me thinking. And it turns out that many provisions in an alliance agreement are really not susceptible to informal enforcement. For example, if an innovator has missed meeting a clinical trial deadline, that might violate a performance covenant that's in the agreement to meet that deadline. But the response might well be not informal enforcement, but rather a move to ask for specific performance to get the clinical data so that the parties can then proceed with the help of the biopharma company for a successful drug discovery. Another example where informal enforcement wouldn't really work is in a Biogen agreement where there are exclusivity covenants for modality targets. And if a party doesn't use what's called commercially reasonable efforts, then the exclusive license will convert to a non-exclusive license. Well, informal enforcement doesn't help transfer or get what it has been an exclusive license into a non-exclusive license. That is something that is only really possible through a court enforcement process. So what are the limits on informal enforcement? Well, I've talked about some of them. Another thing that was suggestion in interviews is that there wouldn't be any kind of sanction unless the innovator were purposefully not fulfilling their duties. Okay, so continuing on with this theme of the difficulty of informal enforcement in this context of biopharma, think about the fact that if the issue is the right to enforce patent rights, the failure to enforce patent rights might have dire consequences. So you cannot informally enforce when a party fails to defend a patent right. What you need instead is a transfer of the right so that at least one party can be defending the patent right. Okay, so discriminating alignment. Let's come back to that theme. So we've talked about the difficulties of informal enforcement in biopharma. Now I want to talk a little bit about discriminating alignment. Where do we see it? Okay, one of the places that we see discriminating alignment is in the selective use of committees with mutual consent requirements. So in the manufacturing setting, the use of committees with mutual consent requirements is pretty rare. Now, Lisa Bernstein indicates that the use of committees might be increasing, but so my evidence is that it's pretty rare. So, so why might this be? Why might there be a selective use of committees? Well, when you think about it, if an original equipment manufacturer has alternative means, such as hierarchical control to achieve its goals, what are those goals? Error detection, quality control, and can dictate to the manufacturer buy fewer goods that don't meet the standard, or simply say there is no purchase obligation unless the goods live up to the standard, then there's really no need for the added cost of a committee with mutual consent requirements. Now, one thing I found interesting was that even in the innovation sphere, outside of biopharma, there is a selective use of committees. So I talked about no or rare use of committees with mutual consent requirements in manufacturing, a lot of use of committees in biopharma. But I interviewed a company that had a very innovative product, but they didn't use committees. And let me talk about what kind of company it was. Well, the company had a very innovative machine, and they were only working towards improving or tweaking the machine. They had a machine that would measure the interaction of cell technology for combating cancer cells. And basically, each party could benefit from the exchange without the need for any complex committee structure. So the manufacturer of the machine would lend it to the parties doing research on cancer cells, and they could then decide whether or not the strategy they had for combating cancer cells was effective or not using that machine. And then they would go back and say, oh, well, is this cell technology effective? How can we, improve it? And then the manufacturer of the medical device machine would go back to its office and decide, is there anything we can do to improve the operation of this machine to help these companies? But they weren't really coordinating together. So you can see at all levels, in different contexts, parties are making use of the discriminating alignment to choose the most efficient situation for them. Okay, so I want to talk about what I learned from interviewees who talked about the committees, because the Joint Steering Committee and all of these other committees have been referenced for different purposes, or talked about by scholars as serving different purposes. One was, as Professor Matt Jennejohn said, to police the boundaries of IP. But there are other purposes of these joint committees, and I wanted to talk about what people told me. To move the project forward, to build knowledge, not trust, to crystallize methods for bringing forward problems, to allow for the exchange of outlooks before problems bubble up, to emphasize shared control so that there is buy-in by both parties. They would agree to rules that they would jointly formulate. Okay, So what makes success possible in biopharma? So what came across over and over was the joint incentives to success and for both to profit. That lessens the need for informal enforcement during drug discovery. During the discovery process, both parties are aligned 150%. Quote, that's a quote. The trade-offs, another important thing for success was trade-offs that even things out between the parties. Thus, even if one party shoulders marketing expenses this year, next year that expense will fall to another party. It's part of the need for a collaborative culture. Another theme that came up was best practices involving people, and I think this relates to things that have been talked about earlier, who will execute the alliance into the drafting of the alliance agreement. Another theme was a balance of power so that, oops, my quote, neither party feels bulldozed. Okay, there it is, that's the quote. So that neither party feels bulldozed. Other factors, win-win mentality, and maybe another interviewee revealed that maybe the most important thing is an extensive development plan that runs hundreds of pages and is more important than the alliance agreement itself. So then I asked about what keeps parties from defecting. Because of course, one of our problems in any kind of relationship with an external firm is opportunism. And first of all, people told me that misappropriation of intellectual property was rare. And then there was this theme of, well, what keeps parties from defecting or engaging in bad behavior? The contract language on commercially reasonable efforts and incentive alignment. I think that's a theme of one of our next speakers. And the lock-in provisions that keep them from defecting while success is still possible. Okay, I'm coming to the end of my talk pretty soon. I wanted to talk about another theme though, and that is one of the things that really became apparent from looking at the provisions, talking to people, was the idea of the need to keep the parties on track. So that interviewees suggested that if an innovator was faltering, they would supply the expertise to get the project back on track. The most important thing is to have this project be successful. So how does that relate to contract provisions and other scholarship? So the mutual consent requirement has been conceptualized partly as a response to Matt's language, multivalent problems such as spillover. But it's also possible to reconceptualize the mutual consent requirement as one of keeping the parties on track by encouraging the parties to solve the problem before it escalates. Because the result of a lack of unanimity is escalation to CEOs. And the parties involved in an innovation project do not want to escalate to CEOs because the CEOs will be very angry that so much money has been invested in a project that now has a problem. And so what will they do? They will solve the problem. So the unanimity requirement in these alliance agreements, I began to see as sort of serving a different purpose. In addition to protecting IP boundaries, it keeps parties on track for success. And because knowledge is interdependent, there's a need for both to work together, and there's so many coordination issues that it's required, you have to have mutual consent. Okay, so where an OEM can decide, oh, there's, no, that doesn't satisfy, there's no need for this extra requirement. So authority reversion is something that I didn't focus on, but I learned about from the work of Jeff Royer and Hanisch, and that is that there are sometimes contingent reversion provisions in these agreements, which I then looked at, and those contingent reversion provisions, then if there is a deadlock, it says, well, it reverts to a person with expertise, or if we're talking about commercialization, the party who's going to commercialize it will make the decision, and that too keeps the parties on track and solves the problem. And again, that's consistent with success is everything as a theme here. the keeping parties on track could also is also reflected in some clauses that allow the biopharma company to have a modification in lieu of termination. So biopharma does not want to terminate the agreement, and that's consistent with this keeping parties on track. And so they have step-in rights that allow biopharma to take over the project if the innovator fails to meet a development milestone. Now, this is where it gets complicated, because at the same time, you could say that this is consistent with keeping the parties on track and making the project successful. It could also be that they are empowered to reduce future royalties payable to the innovator if there is a failure, a material breach, or a failure to use commercially reasonable efforts. And so that could be some indication of some kind of informal enforcement going on in the discovery process. So I would say it's a very complicated process. Okay, and then I'm going to end with these clauses, which I'd be happy to share. The modification in lieu of termination and the step-in rights, which can occur not only when there's a failure to meet a clinical trial, but also a step-in right when one party fails to adequately defend the patent right. So again, we want to make sure that this project goes to success. And I just want to thank everybody for listening.
So I'm Geerte, and I wanted to thank Juliet also for inviting me to be on this panel. I mean, I think it started actually a few months ago when Juliet had read one of the papers I had co-authored on, amongst other, governance and relational contracting, and she reached out to me, and now I'm here today. So I'm very delighted to be here, and I'm not the traditional scholar, but I've actually switched from academia into practice, and I've been in-house for over 15 years at in many different industries, actually, from high tech to life sciences to consumer and B2B products, as well as from a scale-up perspective and a multinational perspective. So I see many different sides of contracting and the way contracts and strategic alliances work out. And today I just wanted to share some of those insights with you, which I hopefully provide some food for thought for some of your research. And I've been hearing this morning and today already very many interesting perspectives. So when I mean, looking at the governance of contract, I look at what McNeil has said. I heard it here today as well from Lisa Bernstein and from Juliet. So I think it's not only the contracts or the paper that matters, but it's a lot about the context which surround it and social, cultural, social economic factors, and also the specific characteristics of contracts. So context really matters in my view, and the paper contract is just one piece of the relationship that parties build with each other. And so I wanted to dive into a little bit the supply agreement. So as we've also heard and seen is that, you know, in the past there's been a lot of vertical integration. In the last few years, firms have kind of looked to third parties in order to decrease their risk profiles and increase costs, and they start contracting more and more with third parties. And so if you look at in the manufacturing industry, and I think, by the way, that what I'm going to say holds across different markets and sectors. So I'm going to talk about when parties go and source and procure products or components. I think an important element which colors the relationship and the contract is the degree of uniqueness or standardization of the component or the product. So if you look at large manufacturers, and if you go to the far standardization side, it's what many manufacturers of, for example, consumer products have done in the recent years. They go to, for quite a standard product, and go to suppliers that do this for multiple companies. It's called white labeling. So you actually enter into an agreement with this supplier, and you have very little customization, and the supplier just puts your brand on the product and then it gets shipped out. So you might see, and you might recognize this, there maybe products of several suppliers would look quite, manufacturers look quite similar, but that's because they use the same type of supplier. And when you see that degree of standardization, it also translates into the contract, because if you look at the contracts, the supply contracts that are made in those types of relationships and situations, they're very standard. So everyone always starts with their standard master supply agreement, excuse me. And you see in these types of relationships, there's very little room for negotiation. And so the standards actually very much prevail in the relationship, and they're pretty standard as well. So they usually have very simple dispute resolution, mechanisms. Often they go directly to a formal enforcement like a court or an arbitration. One of the key elements of these relationships are the quality provisions. So does a supplier meet your quality requirements, which is what the parties actually put some of the more effort into, because you want to make sure that if you source a product from these suppliers and you later get a claim, you know the quality was okay. And also the switching costs are very low. So often there's clauses on termination. The termination for convenience is pretty standard, so parties can walk away from the relationship pretty fast, which means that there's not really a vested interest often for these parties to prolong the relationship over a very long period of time. I mean, they do, but they want to keep the flexibility to switch to other suppliers. And as they're more standardized and customized products or components, there is also that availability in the market. So parties also invest less in the relationship with each other in this degree. Now, if you move from these more standardized type of relationships to a product or component which is more unique, you get into a piece, for example, which is not a full collaboration. Excuse me, I'm going to take some water because my voice is not so good. So what you see before you get into a full-blown strategic or collaborative agreement where you talk about really unique concepts and products, what you see is, for example, supply relationships where the buyer has its own design. So they really want, they have a certain design for the project, and they're already looking at suppliers which are more sophisticated, and for which they enter into the agreement, where you get into the next stage of the contract and what is important in the contract. Because what becomes important in the contract is who owns that design, and if anything goes wrong later on, who has the liability for the flaws in design, right? So here what you're often asking to do is you want to keep ownership of your design. So IP rights become much more important, and negotiation around those rights in your contract. But also what becomes important is the supplier going to change any of its manufacturing processes to accommodate your further customization? So are you going to invest, and is there a shared allocation of investment with these suppliers to customize their manufacturing process to accommodate your design? So what you see in these relationships as they move from the very standardized component or product into this intermediate phase where you get a more designed and customized product, there's a more intense collaboration and relationship, which translates into the contract. So termination for convenience is not a given thing. Parties are going to be much more concerned about when you can step out of this relationship. And they're going to also be looking much more at informal dispute resolution mechanisms in your contract. So what you often see here is already that there's a tendency to sometimes form joint committees. I mean, not to the extent that you see in strategic alliances or joint contractual collaborations, but parties already put more focus on that. So as the uniqueness of your component and product becomes higher, you see a sophistication of the contract and the different elements of the contract that need to interact and play a role become much more relevant for parties as well. And I think as you move, and switching costs are also higher. So an interesting concept at companies is always, when you source from a third party, what is your ability to escape, right? There's often internally in companies, we often talk about second source. Well, second source is a very nice theoretical concept, but to really second source a supplier comes at a very high cost. Now, when you have more very standardized project, you might look at suppliers that could do the same job, and you might already identify them and start building a relationship with them to switch if you have an issue with the current supplier. But as your design of your component or product becomes much more complex, this actually becomes to be a very theoretical concept. Because to be able to set up a second source, you need to invest in that supplier. You need to give them volume commitments. You'll need to put a lot of energy in that, but you still have your first choice supplier as well. So do you have enough volume to spread across these different suppliers? Are you really going to invest in a second relationship if it's already taking you a lot of cost and investment to stay with this one supplier? And how do you know what the risk is of this one supplier that you've identified as your preferred supplier for this more customized and unique product to then switch to another? So these are interesting challenges at companies, and often what happens is once the relationship breaks with your very unique supplier with your unique design, that's when you start looking. But that's actually when you're ready to late, right? Because then the relationship has already broken down. I also wanted to, I think the uniqueness of products and components also translates in part to the uniqueness of parties. So this is what you actually see as well if you look at the high-tech industry. You talk about regarding companies like ASML, the chip machine maker, or ASMI, the company that actually delivers the material from which chips are made. So for these companies, they require a very unique supply chain. So if you look at ASML, for example, they have set up a supply network of thousands of suppliers in the area they actually operate. So this network effect also has an impact on the way you look at your contracts. It's not only the network effects, but I think what plays a role here is for ASML, every supplier is unique. Their machines are of such high tech quality, and the elements in their machine are so precise and high tech that they usually have very unique suppliers for every component. Now, that means also that the relationship they're looking for, so it's not only about unique component or product, it's also about uniqueness of the party. So ASML is a very unique party, and the suppliers they have are one of a kind. So this combination creates a very interesting relationship. And if you then look at the contracts which they have, these become sophisticated in itself and tend often more towards collaborations or strategic alliances, whereas they're actually in essence supply agreements. But what also makes it very interesting, and I think is very important for scholars to understand, is that the relationship translates way beyond what's written in the contract. So if you look at some of the dynamics in the network of ASML, for example, you will see that they're so reliant on certain suppliers that if the relationship breaks down, if something in the contract breaks down, or the supplier gets into financial distress, many mechanisms outside of the contractual realm will actually start working. So a company like ASML or a company that has a unique position has relied on a unique network of suppliers will actually go beyond what the contract is asking in order to stabilize their network and be able to ensure supply. They will, for example, start issuing loans to companies in financial distress. In these situations, they will actually break away potentially from third-party supply. They will actually acquire some of these suppliers in order to safeguard, their supply chain, because losing one of the suppliers in this long chain of suppliers is very fragile. So if you lose out on a single component, you won't be able to manufacture your product. So what you see here, and that also goes to some of the, I think, interesting elements that Lisa Bernstein addressed, is in companies like these, beyond the contract and the committees written in the contract, the companies will actually delegate specific business professionals, so managers that are dedicated to managing the relationship with these suppliers. And their responsibility is to really ensure that beyond the contract, there's a good relationship. There's informal dispute resolution mechanisms that business managers and different layers of the organization can actually find each other to resolve issues and conflicts when they arise. So the contract is really the last resort, let's say, in some of these relationships to go to. It's when everything has broken down to such an extent that you will need to resort to the contract to see if there's still an ability to mend the relationship and get out of it. And usually, unfortunately, once it's there, you might also see that the informal dispute resolution might not get you there, and that's when you sometimes see the larger litigations arising from these strategic relationship or supply agreements because it has broken down to such a fundamental extent. So, but apart from, before going there, I think what's relevant to mention is in these very networked communities, reputation is a big thing. So that does, reputation is a factor that will also help to address asymmetry or foul play, or because if you do something which is not appreciated or do it in bad faith or work the contract in a way or terminate without cause, without reasonableness, the community will be there to address. And since the relationships are so unique, it will be very difficult for these types of suppliers with a damaged reputation to then continue to be a part of that network. So usually what then will happen is they will just be ousted out of the network, and usually you see these companies go bankrupt and have no further kind of productivity or profit because no one will work with them anymore. So I think that's a very strong enforcement mechanism in these types of communities. I think it works across industries, this network effect that's there. And so it's just to raise that what something like this that you also see in other industries. So for example, in public-private partnerships, it's run for many years, and that's something that the company that I work at now is very much involved in. Also in the US, you'll see that there's very standardized, actually, tendering contracts, which you have to agree to, and there's little room for negotiation. But these relationships, once you win a bid like this, they run for 50 years maybe, or we have a contract that runs for 99 years. So it makes it very relevant that beyond the pure contractual terms, parties will need to build a relationship with each other, which provides room and flexibility to accommodate for issues as they arise. Because closing a contract now, 50 years from now, or even 100 years from now, things will have changed in your context and also in the joint venture and the stakeholders that you're dealing with, because parties will also move in and out of these relationships. But what remains is the relationship with the governmental authority and the fact that you have to run this infrastructural project or development. So again, there, the context of the contract, and I think the different also business and cultural elements that Lisa Burton also alluded to are very important in these long-term relationships. And then maybe finally, because I know we have limited time, I did wanted to also address some of the other elements that I think can impact the way we look at contracts and governance of contracts. I think that's something that Matt also brought up, and that's industrial policy and laws and regulations. So an interesting development, just to carve one out, what we see in Europe is, as I mentioned, we've seen a lot of firms moving out of the vertical integration, the way they set up their supply chain into sourcing from many different suppliers. Now, if you look at European legislation, for example, we see a huge increase in ESG, so environmental, social, and governance legislation. In particular, in Europe, what is playing a large role for companies now is the Corporate Social Sustainability Directive and the Corporate Sustainable Due Diligence Directive. The CSDDD, that's how the last one is actually called, calls for parties to upstream and downstream and within their own operations have control of everything that happens with regard to human rights and environmental footprint in the food supply chain. So this is something that companies actually are looking to very critically. It's a very interesting thing which could move, in my view, perhaps even turn the movement back again to vertical integration and the way parties work with each other. Because as a company, if you're made responsible for your full supply chain, which could consist of thousands of suppliers, but also for your downstream activities, and you have to prevent, mitigate, monitor, remediate anything related to human rights and sustainability and your carbon footprint, that means you need to you have to enforce a lot of control into your supply chain and even into your contracts. The sanctions for not complying with this could go up to 5% of your global revenues. So it's interesting how I will be interested to see how these types of sanction mechanisms and these very large legislative initiatives and impacts, which are European-wide, might impact a way that, especially in a supply, supply area, companies will be impacted to maybe change the relationships they have with their suppliers, not only on paper in a contract, but also overall. How do you monitor? And if you're sanctioned to that degree, are you going to pass some of that along into your contractual relationships and agreements in your supply chain? So I think those are very interesting. The same goes for the way you look at the formation of networks and communities and the impact that terrorism and economic sanctions have. So we've seen a large increase of terrorism, economic sanctions, and export controls. And we've also seen the impact of things like COVID. But what this has done, for example, in Europe, these different, so COVID, but now also because there's a lot of policy around export controls and sanctions, you see that companies are pulling their supply chain back into an area which is near to them. Whereas first companies had outsourced a lot of their supply to China and other countries, they're pulling that closer again, which means that reputation again becomes much more important in the way that you look at the governance of your or contracts and relationship. Because by pulling it back into Europe, as we see many companies do, the network and the community is smaller, so reputational effects are again much larger, and also you have a closer relationship and more control on your supply partners. So I think those different types of movements are very interesting and very relevant for the way we see firms picking up on their contractual and governance relationship with parties. And I'll leave it at that, so thank you very much.
Few minutes for questions. Mike's having like for purposes of the recording.
So really interesting panel. I have many questions, but I'll just ask one and hopefully get the others. And I wanted to ask, I guess, Julia, that's really interesting and learned a ton. And I wonder if, so you say the distinctions between manufacturing and biopharma, and I guess I'm wondering rather than if the distinctions between sector or if it's really maybe between stage of production and bargaining power of supplier. So when manufacturing innovates, so when you see General Motors doing a joint innovation project with the supplier, you see more equal bargaining power. As I guess I don't know what the formal contracts look like, but you do actually see some of these more equal, I guess, provisions. And then I guess I was also intrigued that there are things that I've seen in manufacturing that I don't know that they're in contracts, but I have actually seen what you called modification in lieu of termination. One thing would be that I know it's not in the contract that we give you a price increase, but if you're going to go out of business, we'll give you the price increase.
Right.
So that'd be sort of one kind of example. So anyway, I just thought it was just a really interesting wealth of examples and about the difference. So I think that the discriminating alignment works really well. And I guess but I did have one other question I thought your point about why the informal sanction didn't work well in biopharma was really interesting, but I wondered how the courts fixed it. So if you have, if you don't want to signal a problem with a project, going to the courts also seems like that would make that public. And if you want to be seen as a good partner, so you don't want to sanction your innovators, wouldn't going to the courts also suggest that you're litigious and bad? So I just wondered. Yeah.
The response to a faltering problem, and then the response is not sanctioning them. Your other alternative is really not to go to the court. So that's not the other alternative. The idea is that if you encounter that situation, you may in fact do something like if there was a problem with the clinical trial not being met in time, you may take it over and request specific performance to get the clinical trial information to date. I take your point about there are some situations where there's collaboration in an innovation sphere between GM and someone, but the let me see what I want to say. So that you could have more collaboration. But from reading Josh's book, the new old economy, a lot of the relationships seemed quite adversarial, and the idea of a production of a 5% letter to tell the supplier then you're going to reduce your cost by 5%, and of course you're really not going to come out ahead as a result of this, doesn't seem to be a collaborative approach. There seems to be more adversarial situations that I've read about, although and done some interviewing in an article on the LPAs. But I'm not like an expert like you and Lisa and Josh and Matt on the manufacturing sector as much. But it seems like I mean, another title for the paper might be Discriminating Alignment or the Anatomy of Success, which is the opposite of anatomy of, Josh's paper, Anatomy of Failure. They just, and then on, in terms of collaboration and innovation, I talked to an interviewee who said, well, we work with an OEM, and we have something really innovative, or they ask us to innovate with them. Well, we never do that. We just give them old technology on which we have a patent. Because, so it's a self-protective kind of strategy.
When we make this the last one.
Okay, I'll just very quick comment on the 5% letter, and going back to one thing that Lisa said, and Sue knows as well. So the engineering side of those companies kind of hate the 5%. I mean, the engineering side of the buyer hate those 5% letters. I mean, they screw up because suppliers do have ways, even if they have to do it, of say not be, performing but not performing well. So it's complicated. They're adversarial, but they're fights internal to the OEs about how adversarial you want those relationships to be. There's sort of internal disputes around the way to do that. But I'm going to move that into a question that maybe could go to both Juliet, but also Jorge. And then I'll frame it towards Jorge and then bring it to Juliet. One of the things I'm interested in around what you're looking at, which is fascinating, about sort of getting these consensus contracts, because you're talking about how they come about, how they work, and thinking about how they sort of remove transactions costs and basically remove frictions and just sort of take out the bargaining and everybody agrees. One of the things I'm interested in that you didn't talk much about is not just what contracts are, but what they do. So this is the kind of thing sociologists in some science technology studies where you think a lot about is like, you have a coordinating device. How does this make the world different? How are designs different? What does this contract do? Or is it just a Macaulay contract? Fine, we don't have to bargain. Then we just have the relationship. But what do contracts do? So this is the kind of thing also in discriminating alignment. If you get contract styles, how do they structure the relationship themselves, or are they just functional to the relationship? That's, we got this stuff worked out. So it's just dead weight loss, or do they make the world somehow in ways that it would otherwise be different?
One of the areas in which that comes out most clearly is the construction industry, right? That the way the contracts were structured really did define the way that these different stakeholder groups interacted with each other. Architects, you could conceive of a world in which an architect is just some outside entity that hands off a set of plans to a contractor who then takes over the building. But if you structure your contracts, if you're an architect and you structure the contract so that the architect is really viewed as the mastermind of the whole project and is there at every step representing the interests of the owner, and the contractor is just some, a mechanicer who puts bricks on top of each other. I mean, that's a different world, right? And so the contracts really do affect the way the parties interact, and this is why the contractors have their own set of agreements, where they are the ones who really just cut the architects out of the picture. You hand off plans from the architect, and the contractor does it all and interacts directly with the building owner. So there are, I think there are important functions, and I think the differences in the sets of contracts really define different ways of doing business.
So, in the biopharma context, so you might say in the manufacturing context that the contracts provide a way to monitor what's going on the assembly floor. It has a quality control going. You have engineers there to monitor. You have reports generated. But in the biopharma, you're getting together to look at clinical data, and maybe John Murray should be talking now, to determine things like cause and effect. That's a very different point of having a committee to determine, well, what's the cause and effect on this clinical data? It's to coordinate, it's to make sure that both parties are that's why I think part of it is shared control, because they both have this knowledge without which the project will not succeed. And that's a very different thing than monitoring. So I'm not sure I have a word for it, but it's different.
So why don't we save it for the break? And I hate to cut off some great questioning from the great
We'll
panel,
come find you.
but
That's okay. I just wanted to add something about clinical trials, because that's what I do.
quick comment.
Yeah, I was just gonna say on clinical trials, there is monitoring and everything in the clinical trial agreement as well.
Well, thank you for a wonderful panel. Definitely did not disappoint.
I think you should start.
Yes, online.
Oh,
I don't know if she can see us.
Okay,
But I'm trying to do something where I was watching this. Liza, can you hear us?
Liza, can you hear us?
Yeah, I
Okay.
can. Yep.
Can you see us?
Yeah, I've seen you all day. I wish I was there.
I apologize. I told her you can see us, so you can. Okay.
Yeah.
So it won't. What? Yeah.
I'll be right back.
Rob, we're about to start. We couldn't do it without you.
Okay, so thank you everyone for joining us for our last panel. Technology transfer, biopharma, and biomedical innovations. I'm really excited. We have amazing panelists here. I'm going to introduce them briefly, and then I'm going to give them the stage. We have Peter Lee, who teaches and writes in the field of innovation law and policy. His research focuses on patent law and other fields of intellectual property, technology transfer, artificial intelligence, and science policy. His recent scholarly works explore the social context and implications of innovation and the structure of innovation in creative industries. Professor Lee's scholarship has appeared in the Yale Law Journal, Stanford Law Review, California Law Review, the Duke Law Review, and he's an elected member of the American Law Institute and has received numerous awards for his scholarly work, including the UC Davis Chancellor's Fellowship. I must say our former co-dean, Dean Berg, is there, so you're lucky for having her. We missed her, so please tell her we said hi. And next we have our graduate alum, John Murray. Thank you for being with us today. He graduated from Case Western Reserve University School of Law in 2012. He's currently an associate general counsel at AbbVie, where he advises on mergers, acquisitions, strategic collaborations, and intellectual property licenses. And he's been with them for the past 7 years, during which time he led in-house attorney on transaction, aggregating over $20 billion in transaction value, including key acquisitions of Immunogen, Cellulose Therapeutics, and other companies. So thank you so much, very proud. You have to come back and talk to our students, as I mentioned before. And joining us online, Liza, thank you so much. Liza Vertinsky is a professor of law at the University of Maryland, and where she teaches and researches on the intersection of law, economics, and social justice. She's a nationally recognized expert on the regulation of healthcare markets and emerging technologies and the role of public-private collaborations in innovation and access to medicine. Professor Vertinsky clerked for Judge Stanley Marcus, the first for the U.S. District in the Southern District of Florida, and then for the 11th Circuit Court of Appeals. Then she practiced for a decade at 2 top law firms in the greater Boston area, focusing on intellectual property transaction in the biomedical industry and university technology transfer. She joined the Emory Law School faculty in 2007 and the Maryland Carey Law faculty in July 2022. So thank you, everybody, and the stage is yours. We'll start with Peter.
Well, thank you very much to Case Western for putting on this great gathering and for inviting me. I really enjoyed the conversation thus far. I'll just give it a second to load up. All right, great. So this is a project called Relational Contracting and International Technology Transfer. So let me give you a sense of what I'd like to cover today. I want to talk a bit about the conventional role of patents in international technology transfer, then the limitations of patents and the need for relationships to transfer patent-related technical knowledge. And I'll help you illustrate this through a variety of case studies of knowledge transfer in global biopharmaceutical partnerships. All right, so I've been interested in quite some time in this question of how do technologies and technical knowledge move between countries. And obviously there are dozens of mechanisms of international technology transfer. We have cross-border licensing, foreign direct investment, international trade. You could add conferences like this, Wikipedia, ChatGPT, lots of different channels. In IP circles, we tend to focus on the role of intellectual property rights in promoting international technology transfer. And there is, I think, a wide consensus that patents do promote international tech transfer. And in fact, it's reflected in the fabric of international intellectual property law. We have the Agreement on Trade-Related Aspects of Intellectual Property Rights, the TRIPS Agreement. This reflects substantive harmonization of IP standards for all members of the WTO. Article 7 says the protection and enforcement of intellectual property rights should contribute to the transfer and dissemination of technology. All right, so how exactly does this happen? Well, economists recognize several different channels by which strong patents can promote technology transfer. So if a receiving country has strong patent protection, I might be more likely to export my technological goods to that jurisdiction. Similarly, I might be more inclined to engage in cross-border licensing. So licensing my technology to entities in that country. And finally, I might be enticed to engage in foreign direct investment, actually building factories, research facilities, laboratories, again, in countries that offer strong patent protection. So for the purposes of this talk, I'm going to focus on the latter two categories, right? So transferring not just some end-user technological good, but the actual capacity to manufacture technology overseas. All right, so if we disaggregate the transfer of patent technologies, we can identify at least two different components. Obviously, there's a legal component. The receiving entity must have a legal right to practice the invention. This can be accomplished through voluntary licensing, compulsory licensing, IP waiver, as was the case with COVID-19 vaccines, or even patent expiration. In parallel, however, there's a cognitive component as well. The receiving entity must have the knowledge and capacity to actually practice the invention. So the legal right to practice the invention is rather empty if you don't have the knowledge to actually make and use it. So again, we're focusing on the transfer of patent technologies, and take a little bit of a detour into patent law. And in theory, the patent disclosure itself satisfies this cognitive element. So patent law is embedded in a broad societal quid pro quo, where you give the inventor 20 years of exclusive rights. In return, you have to disclose your technology. This is illustrated in the disclosure requirements of U.S. patent law, 35 U.S.C. section 112, the most pertinent requirement being enablement. A patent must teach a technical artisan how to make and use an invention without undue experimentation. So the notion is that a technical artisan can sit down and read a patent and understand how to practice that technology. As the late Dan Burke observed, codification results in commodification of knowledge, allowing it to be treated more as an object of trade or exchange. So if we assume that patent disclosure is robust, essentially technology transfer is accomplished with the mere transfer of legal rights to practice some invention. All right, so I want to challenge this conventional narrative. We're talking a bit about the limitations of patents and the relationships to transfer patent-related technical knowledge. So patent disclosure is limited in a number of ways. I'm going to focus on two today. So one kind of technical knowledge that's not actually conveyed by patents is so-called tacit knowledge. Michael Polanyi, philosopher and scientist, once observed, we can know more than we can tell. So tacit knowledge is personal experiential knowledge, not amenable to codification. So a master chef could write a recipe describing how to create beef Wellington. I guarantee you if I follow that recipe, my dish won't taste nearly as good as that of the master chef. Right? So I lack the chef's tacit knowledge, born of years, perhaps decades of culinary experience, even things like muscle memory. So the patent concept is talking about technical know-how not disclosed in patents or other documents. And tacit knowledge can operate on multiple levels. So the tacit knowledge of the inventor may be helpful for practicing some basic version of the patent invention. It may also be very useful for commercializing an invention at industrial scale. So there's a big difference between making one dose of vaccine and then designing some industrial process to create hundreds of millions of doses. And tacit knowledge of the inventor may be useful, in particular for that latter task. All right, so a second type of technical knowledge, not disclosed by patents, are trade secrets. So here we're referring to technical information that's the subject of reasonable efforts to maintain secrecy. This may include tacit knowledge. So tacit knowledge may be protected as a trade secret, but this also includes codified information, which by definition is not tacit, such as instructional manuals and manufacturing specifications. And while trade secrecy and patent protection are considered to be mutually exclusive, patentees routinely retain invention-related trade secrets. For instance, we might have a recipe for the industrial manufacture of a vaccine. This is a written recipe, it's not tacit, but yet it's not disclosed in a patent application. All right, so there are some transactional hazards of trying to transfer patent-related tacit knowledge and trade secrets. So you think, well, you can license patents, why can't you license tacit knowledge or trade secrets? So you can in theory, but there are some complications. So tacit knowledge often requires direct interpersonal interaction between inventing and receiving entities to convey. This may require on-site demonstrations and training, the kind of high-touch, long-term relationships not so amenable to one-off market transactions. The trade secrets, these may be codifiable. So yes, they can be licensed and they are licensed, but there are trust concerns with sharing information in one-off market exchanges. So the risk of expropriation from the receiving party disclosing or using information in an unauthorized manner. All right, so how can we overcome these transactional hazards? I want to suggest that we have organizational and relational solutions that can be helpful in this context. So varying degrees of integration between invented and receiving entities can overcome these transactional hazards. They facilitate long-term personal interactions that transfer tacit knowledge, and they facilitate trust, enable monitoring, and align incentives to safeguard the sharing of trade secrets. All right, so we really have a continuum here. One end of the spectrum might have an integrated global firm that transfers technology from its headquarters to an overseas division, right? So here we're doing this all within one organizational context, through the shared context in which we can facilitate the transfer of tacit knowledge, meet corporate boundaries, and help prevent the leakage of trade secrets. Abstracting from this, we have international joint ventures, which can create a common space, again, for transferring tacit knowledge. They can align incentives, create monitoring regimes that actually facilitate the transfer of trade secrets as well. And then at the far end of the spectrum, we can think about thick, long-term relational contracts. So these are between two formally distinct entities. They have a thick set of relationships that again facilitates the transfer of tacit knowledge and engenders trust, which facilitates the transfer of trade secrets. I'm going to focus for the remainder of my talk on this last category. I'm going to drill down on the relationship between biopharmaceutical companies and contract development and manufacturing organizations. All right, so I'll then engage in a few case studies, walk through a few case studies of knowledge transfer and global biopharmaceutical partnerships. And so first a word about contract development and manufacturing organizations, or CDMOs. These are entities that enable biopharma companies to outsource several functions, including drug research and development, the manufacturing of active pharmaceutical ingredients, and fill, finish, and distribution services, right? So general structure here, you have a biopharmaceutical company that's the product sponsor that outsources various functions on the value chain to a variety of CDMOs. There are scores of them around the world in both developed and developing countries. Outsourcing accounts for 22% of pharmaceutical manufacturing, and international technology transfer between biopharmaceutical companies and CDMOs involves a lot more than a one-off patent license. So this is illustrated in a number of dynamics. I'm going to focus first on the global manufacturing of COVID-19 vaccines. So COVID-19 mRNA vaccines are patented in jurisdictions around the world. Ostensibly, these technologies are disclosed in those patents, but the industrial manufacture of COVID-19 mRNA vaccines requires substantial tacit knowledge and trade secrets. So according to one vaccine expert from Doctors Without Borders, you need someone to share the process because it's a new technology. One of the problems we have is that the scientific literature about industrial scale manufacturing of mRNA vaccines is so slim. That's why it's not just about a recipe, it's about an active and full tech transfer. And this is illustrated in a dynamic between Moderna, which is a US firm, and Lonza, which is a Swiss CDMO. In 2020, they entered into a 10-year strategic collaboration agreement to manufacture Moderna's COVID-19 vaccine. And so, in addition to patent licensing, this agreement provided for active technology transfer, including know-how, documentation, specifications, standard operating procedures, analytical methods, and process validation documents. In addition, there was a significant organizational interpenetration between these two entities. So this agreement enabled Moderna personnel to actually work in and observe Lonza's facilities. And there were particular contractual terms aimed at safeguarding trade secrets. So the agreement says the parties recognize that maintaining confidentiality and trade secret nature of the Moderna manufacturing know-how requires an even higher level of vigilance than other confidential information. All right, so we see a similar dynamic in the relationship between Pfizer and BioNTech and a variety of CDMOs. So these companies have technology transfer agreements with over 20 contract development and manufacturing organizations around the world. Here again, these are not one-off patent licenses. These are very thick relationships that facilitate a lot of knowledge exchange. So according to Pfizer, for the COVID-19 vaccine, the team at the external facility would need to be trained on many aspects of this complex manufacturing process, from learning the intricacies of formulating lipid nanoparticles and sterilizing the product to make it safe for injection, right? Or a patent license, but again, a lot of additional relational ties to transfer knowledge. All right, so a lot of these examples involve the transfer of technologies to entities in developed countries, but certainly this applies to developing countries as well. We see this in a relation between Bristol Myers Squibb and Fiocruz and Nortec, which are entities in Brazil. In 2011, Bristol Myers Squibb initiated a technology transfer agreement involving licensing its patents and transferring technology concerning atazanavir, which is an antiretroviral that treats HIV/AIDS. And the structure here involved a production triangle involving our patentees, or BMS, the Brazilian government, represented by Fiocruz, which is an entity of the Brazilian Health Ministry, and a local manufacturer in Brazil called Nortec. We had two stages to this tech transfer. So initially, Bristol Myers Squibb transferred the technology and the actual already manufactured active pharmaceutical agreement to Fiocruz, which then performed the formulation and finished the distribution of the medicine. For later batches, the BMS actually transferred the capacity to manufacture this active pharmaceutical ingredient to Nortec itself. So we have your intensive knowledge transfer and capacity building in parallel to patent licensing. This really reflects industrial policy, one could say health policy. The Brazilian government wanted the ability to manufacture these medications entirely within the country. And so according to one representative from Fiocruz, we acquired all the technology and the drug production knowledge, both in manufacturing and in other processes involved in technological absorption. The areas absorb some part of the drug process, and this experience remains at the institution. Knowledge, equipment, processes, all of this is absorbed technology that remains. So again, we started the core with a patent license, then a much thicker set of relationships to transfer related tacit knowledge and trade secrets. Oh, sorry. Now we're caught up. Okay, so finally, I want to talk a bit about Indian CDMO. So a bit about the evolution of Indian contract development and manufacturing organizations. They've really evolved over the past several decades in terms of both product category and the services that they perform in the value chain. So initially, they focused on small molecule drugs that arose from chemical synthesis. They then ventured into vaccines, and India really is the world leader in manufacturing vaccines. More recently, they ventured into therapeutic biologics. In terms of the value chain, they transferred or transitioned from manufacturing kind of up the chain of development and research. And here again, well, I'll catch it eventually. Long-term relationships between biopharmas and CDMOs are used to share knowledge and develop trust. So biopharmaceutical contract manufacturing depends highly on smooth and efficient knowledge transfer and regular interactions between product CDMO, product sponsors, and CDMOs. So this is illustrated in an arrangement between the International Vaccine Institute, which is based in South Korea, and Biological E, which is based in India. So in 2023, IVI licensed technology to Biological E to manufacture oral cholera vaccine. And IVI's technology transfer encompassed technical information, know-how materials, and will continue to support necessary clinical development and regulatory approvals. Technology transfers set to conclude in 2025, right? So a multi-year process to transfer all the related know-how. All right, so this also illustrated an example of Syngene. So Syngene is a CDMO that's a wholly owned subsidiary of Biocon, which is the largest Indian biotech company. It rolls forward 90 to 95% of its business into the next year. So it really emphasizes the longevity of contracts and building relationships over many years. It has very strict confidentiality agreements with employees, vendors, and service providers. And so in general, we see the augmenting of patent licenses with relational contracts that enables significant knowledge transfer. So this relates as well to capacity building and further evolution. So according to one commentator, India has also been harnessing partnerships and collaborations with global organizations for knowledge exchange, technology transfer, and capacity building. This is an area of industrial policy the Indian government is quite interested in advancing. This contributes to endogenous innovative capabilities, particularly in the context of biologics and biosimilars. Just to conclude here, patents play a variety of roles in promoting international technology transfer, but tech transfer requires knowledge transfer. Patent disclosure frequently does not satisfy the cognitive aspects of technology transfer. Patent knowledge and trade secrets are not disclosed in patents or conveyed in patent licensing. Patent-mediated technology transfer is not a one-off license. We have fake long-term relational contracts that facilitate intensive knowledge sharing. That I will close, and I thank you very much.
Law school that I graduated from and speak to. Thanks for inviting me. So as the introduction laid out, I'm Associate General Counsel at a pharmaceutical company called FD. My day-to-day is filled with the stuff we've been talking about today, negotiating strategic collaboration, strategic licenses. I do mergers and acquisitions as well, and that's my background before working on life science transactions is doing M&A. I didn't know anything about the pharmaceutical world before I started working at AbbVie, and quickly learned that collaborations are not zero-sum. They're anything but zero-sum. And I think we've heard examples of that throughout the day today. M&A can be very zero-sum. You're paying a seller a certain price and you're buying the company, and that's not what collaborations are about. As Ms. Hessen said, understanding relationships matter, context really matters. I'm going to talk a little bit about my practice and in particular the incentives that go into these collaborations in the pharmaceutical industry. I think we've heard various sources just how long it takes and how expensive it is to develop drugs. Anywhere from 10 to 15 years to get from a lead candidate through the clinic to a marketable asset. It can take even longer. If we're starting a collaboration at a discovery stage level, it can take multi-billions of dollars to do that. Most of them will fail. Most collaborations will fail. Most drug development will fail. And that's not because of necessarily a misalignment of the parties. It's just science. Most science will turn out not to meet the hypothesis. However, the contract is critically important as a through line along that 10 to 15 year period to align the parties' incentives. When you think about that time span, personnel at firms change, and strategic priorities change, and the motivations of parties change. So I want to talk about that, and I'll unpack that a little bit with some examples that I see in my practice and how the contract language is really critical, and really the details of the language are really critical. And the details of the language need to be thought deeply about in order to make sure that there aren't any unintended consequences. And we discover unintended consequences all the time in contracts, particularly because you're negotiating something that it is to last 10, 15 years, and you do your best to predict the future. You do your best to predict potential scenarios that the science may lead into, but you can't predict them all. And so you need to form a contract and negotiate a contract that also allows the parties the flexibility to make future decisions without having to renegotiate the contract or rewrite it. And sometimes you can't avoid that completely. I'll start with talking a little bit about the ecosystem of biopharma, and I apologize if this is sort of known to many of you, but the context does matter. Again, in the ecosystem of biopharma, a significant amount of innovation happens at a decentralized manner at hundreds of small biotech companies. I read a statistic that every year there are, 100 or more biotechs that are formed, and they've got an idea, and they're looking to take this idea, and their goal is to create a new drug that is going to change patients' lives, right? They can't do that on their own. They don't have the resources. They don't have those billions of dollars. VC funds don't put up that type of money. They rely on the big pharmas to come in at some point to acquire them or to partner with them. Big pharmas, in turn, don't have the resources to monopolize all invention, right? And that wouldn't actually probably be an efficient way to structure innovation anyway, where 2 or 3 firms invent everything. And so, as an AbbVie, a big pharmaceutical company, we rely heavily on this ecosystem where small biotechs develop things that we never thought about, or never occurred to us, or never occurred to our scientists. And it's quite symbiotic. Those small biotechs and our motivations and incentives are aligned in part at the beginning without even having a contract. Both parties want to find things that change people's lives, right? We are motivated to find cures or to find therapies that can save somebody if they're suffering from something that's fatal, like a cancer, or change an outcome or improve their life. That's the goal. The large pharmaceutical company is the company that's going to take it to the finish line, in the sense of take it to a commercial point. And so the large pharmaceutical company is often motivated to create, that marketable product, to have something that has this efficient patent protections globally, has a scalable manufacturing process, and that they can deploy across a global footprint. A small biotech has a little bit of a different view on the world and the motivation and their role. They know that they're not going to be the one that is selling it, that is the boots on the ground. They're also supported by investors that are looking for an exit, right? So their motivation often is to get to a point where they can find an exit, and that exit may look like entering a strategic collaboration with an AbbVie or a Novartis or a Pfizer, being bought, executing on an IPO. Those in turn have their own incentives and create a risk profile of the parties that diverge. But the contract there are some tools in the contract that you can use to sort of bring those incentives back in line. Where a small biotech is motivated in part to find exits for its investors, it may use that motivation to expedite some of its development in ways that a large pharmaceutical company may never do. I'll give you one example. There was a small biotech company that a compound all the way through a phase 1 clinical trial and started marketing itself as ready to be bought, and that their asset was ready to go to the next step into a phase 2. We discovered that, yes, they had done a phase 1 clinical trial, but it was a form of a clinical trial called a single ascending dose trial. And phase 1 trials, really the purpose is to test certain dosage strengths of drugs to determine whether there's any toxicity and what is the dose at which toxicity, where it can be administered safely and avoid toxicity. They had done a single ascending dose trial and called it a day, and that drug, in fact, was ready to go into a phase 2. And AbbVie and other peers would never stop at a single ascending dose. They would go on to what's called a multiple ascending dose trial, where you're testing essentially multiple doses. And that's just a simple anecdote of the difference of what the two parties view as sufficient for the next step, right? And there's different risk profiles there. A small biotech may be more willing to take risk in development to move more quickly. I guess that's really the point I'm trying to make. Whereas a large biotech firm is more willing to take the slow route in order to avoid a future complication. We know that the FDA is going to ask, what were the results of a multiple ascending dose study? Why did you not do a multiple ascending dose study? So that's just a small highlight of the difference of motivation. Take a glance at my notes, make sure I'm hitting. Okay. Talk to a few examples of how incentives, how the contract can bring incentives back together. Before I get into the contract itself, another example that I made a note to talk about is the impacts of the Inflation Reduction Act and the impacts of the Inflation Reduction Act on the motivations of and the risk profiles of small biotech firms and large pharmaceuticals. The Inflation Reduction Act, as many of us know, imposes a mandatory negotiated price on a selected group of drugs that are selected by HHS. That I believe it's 9 years would be imposed, 9 years for a small compound, 13 years for a large molecule. And that's across, all modalities. So as long as there are therapeutics that share the same moiety, meaning the same active pharmaceutical ingredient, whether it's an antibody or an antibody drug conjugate, that price is applied, right? And so if you have, try and keep it simple, you've got a pill form and then you've got an injectable form. The price is applicable to both of those. Whether you have a drug that's approved for rheumatoid arthritis and psoriatic arthritis and Crohn's disease, the price is applicable to all of them. It doesn't matter, the indication for which it's being prescribed. That latter piece means that you better start your studies of all those indications concurrently. So as you start phase 2 trials and you are starting to put your drug into humans, you want to start trials where you're testing them with patients that have rheumatoid arthritis or psoriatic arthritis concurrently. That's expensive. That's very, very expensive. Small biotechs don't want to do that, right? Because it costs a significant amount of money. So that's a motivation for them to partner with firms like us. Where it can diverge even in the partnership, and you need to be careful about this, and this is where it'll get into, I'll start talking about the contract and how you can incentivize parties, is a form of a license called an option to license. Often, and not to go on too much of a digression, often pharmaceutical companies will take an option to take a license rather than take a straight license. There's lots of reasons to do that. I don't own all of them, but I'm happy to talk further on. If I'm taking an option to license, I can't also be in the driver's seat from a development perspective. And so I want to motivate that biopharma to do all those studies concurrently. Not only do I need to fund them, but I need to develop some reward system for them to achieve those results. And that's where a milestone might come in. So that's where the contract can come into play to increase incentives, bring parties, the incentives of parties together. So let's talk about the economic incentives that are in the contract. And I think it's intuitive that when we're talking about incentivizing parties, the most powerful incentives are dollars. Companies respond to financial rewards. I think the most historical and traditional incentive in these collaborations, because at heart this is a license, as Peter shared with us, are royalties. Royalties, you know, for as long as they've existed, have motivated inventors to invent. It holds true in the biofarm space as it does in any space. When you drill down on royalties, however, there can be incentives that are created in the contract that are very powerful for the invention to continue to take place. There are, if you're not thinking critically about how the royalty is structured, including the scope of the license and the scope of the royalty bearing, the bucket of royalty bearing patents, incentives can get misaligned very quickly too. We'll talk about that, the bucket of royalty bearing patents as sort of a first example. And there can be, and often is in these contracts, sort of a split between a license and what's actually royalty bearing. So, you know, a license, and I'll talk further about this as well later, it obviously is a property right, and as Juliet mentioned, you know, that property right can be an incredible incentive to the parties to be aligned on the same mission to see a successful program develop. Often, if I'm taking a license to a program, that program may be preclinical. That program may be in discovery state. I don't know what the lead candidate may actually look like. It could be compound A until we start putting it into a monkey, and then all of a sudden the monkey develops some toxicity, and we need to go to compound B. And so I need a license that gives me rights to everything, right? To the entire program, and anything that, you know, sort of targets what I'm trying to target within the human body. And there's a lot of hand wringing when we're negotiating these about that. And I come from it from the perspective of a large pharmaceutical company. We want everything so that we can go to compound B. That should be the central motivation of the parties, is finding the right formula, finding the right compound that works. It's not uncommon for the smaller firm to have a different view of it and want to retain some portion of the program that either they can develop themselves or they want to find some other buyer for. That, you know, intrinsically puts us at odds and in competition with one another. I've had plenty of scientists ask me the question of, do we have the right to do X? You know, do we have the right to conjugate an antibody so that if the antibody itself in the pure antibody form is less effective than we want, can we conjugate it and add a warhead to this antibody to make it a little bit more powerful in attacking, you know, a cancer or a tumor environment? It's not a given that when you take a license to a program that you have the right to conjugate that program or to modify it in some way. And so, you know, we posit and we negotiate that both parties should be incentivized to such that the party developing should have full access to all of that stuff. But it's different than what is royalty bearing, because and Juliet, I apologize, it may have been you that talked about this or another scholar in an earlier talk. There's going to be further invention, right? You don't know what is going to come in the future. You're sort of building the airplane as you're flying. Both parties can be inventing, including the licensee. If the licensee is paying royalties on all invents on that full scope, they will end up paying royalties on inventions of their own. That becomes an inequitable result that, as much as you hate it, will play a role into whether that becomes a strategic priority or not. If I'm paying a royalty on an invention that that is my own rather than is the licensor's invention, that may give way to a separate program that I don't have a royalty obligation on. So we spend a lot of time negotiating what the metes and bounds of the royalty-bearing IP is as well. I'll give you another example along those lines. When we're negotiating a patent license, we often, and it's incredibly market to define the scope of that license to be around principally the composition of matter of a patent. Professor Jennejohn here, I'm told constantly that that's the market. That's the market to pay a royalty on a composition of matter. Well, composition of matter really means two different things. It can mean the compound itself, but it also can mean the formulation of that compound. If I'm taking a license at the early stages of a program and it's at a preclinical stage, maybe there's a lead candidate and there is a compound there that has a patent on it. There's likely no formulation there. There's likely no formulation for a commercial scale manufacturing compound, right? Often have drug substance, but you don't have drug product, which is all the unactive ingredients attached to it as well. Those separate patents come later in the life cycle of a development program, and they are often in a collaboration developed by the large pharmaceutical company who has the tacit knowledge of taking drug supply, API, and turning it into a commercial, something that can be commercially manufactured. If the large pharmaceutical then is to pay royalties on that patent, that second patent, it becomes inequitable and the parties' incentives start to fray. The strategic importance of that program the royalty can really weigh it down. So those are just a couple examples. Another example of where royalties can really, and the way you describe and negotiate royalties in the contract can really play on the incentives of the parties is in royalty reduction provision. So most of these collaborations will not only set forth what the royalties are, what the royalty-bearing patents are, what the royalty lifespan is, but are there events that could occur that should reduce the royalty rate? A classic example of this is if I, licensee, take a license from licensor, I get into the program, I start discovering, I start developing, all of a sudden I'm sued by a third party who claims to have some other necessary IP for the practice of this program, and it turns out that they do, and it's blocking. I can't practice, I can't develop the program because what I thought I was going to do was, only A and B, and I don't have C. And so I need to go get, patent C from this other third party, and so all of a sudden I need to, pay more money than what I expected. And under, one formulation, if I'm a small biotech, I say that's your risk, But on what's more traditionally viewed is that no, I should be able to reduce the royalty I pay you because I'm taking a license to be able to practice the full program that you have been developing. That reduction in itself can be a tool, although it's painful. It's a bit of a stick in the collaboration. It can be a tool to align incentives to make sure they're designing the program thoughtfully. Again, this kind of goes back to the example of the single ascending dose versus multiple ascending dose trials. If you shortchange your development program and you do just the single ascending dose, your dosing patents could very well be insufficient and could be trumped by competitors on the market that have gone the extra mile into the multiple ascending dose trials, have gotten more thorough data on which their patents stand, and they could, create some blocking IP that you need to go and get licensed to. So we view those sorts of measures in the contract as aligning incentives of the party along the lifespan of the deal. I touched on milestones earlier. Obviously, royalties only get paid if there are sales. We don't pay royalties until we generate some revenue. And as I said at the top, there may never be any revenue. And so, because most of these programs fail, and so we motivate and we incentivize parties first enter a deal with us by paying them milestones, which can both reward achievements, de-risking achievements, share the risk profile of the program with the counterparty, but also bridge a value gap with their counterparty and allow them to reap some benefit of their hard work before royalties could ever get paid. Where things can get a little wonky and incentives can get misaligned in milestones if you're not thinking about them critically and spending time really, honing the language, is thinking through, does any and all achievement of that milestone constitute sufficient achievement, right? If they go and, as long as they sort of tick the box, and maybe I'll give you the example that I'm thinking of. So it's very, very common in these deals to reward a counterparty if they're in the driver's seat of development for initiating a phase 3 trial. A phase 3 trial is a registrational trial. It's the step before you can apply for drug approval from the FDA. It's the largest trial. It's critical, right? And it is incredibly de-risking when you can initiate that trial. In oncology in particular, this could happen in any therapeutic area, but in oncology in particular, it's quite common to try and accelerate your development by converting a phase 2 trial into a phase 3 trial. Well, that always raises the question, does that achieve the milestone? On the one hand, maybe it should, if it in fact is sufficient by the FDA, in the eyes of the FDA, to be the phase 3 registrational trial upon which a company or two companies can hang their hat. However, it takes greater risk to convert a phase 2 into a phase 3 where you have less patients always in a phase 2. It can take greater risk, and you can always get smacked down by the FDA. We have found this is one of those areas where we structured it one way, paying that milestone upon conversion, and then later learned that this was actually de-incentivizing us and the other party, because we weren't, and other parties weren't willing to always take that risk if they knew that the outcome could be that the FDA says, no, your converted trial doesn't work. You need to go back and actually do a full phase 3. And we had to pay that milestone. And those milestones tend to be incredibly rich, 75, 100 million, on up. And if you have to pay that milestone on top of restarting and doing a full phase 3, which could take, 5 years plus, have all that added expense to it, the calculus before you even converted your phase 2 into phase 3 tended to make us not want to convert, tended to make other parties not want to convert. That's not the right outcome, right? The right outcome is to convert because it could lead to a quicker avenue to approval and get drug into on the market and into patients to save lives quickly. And so we started to structure our contracts differently. to incentivize ourselves, to incentivize our counterparties to actually make that conversion without feeling the pain of taking that risk. And you do that by sort of placing the milestone on the shelf until a time when you receive the FDA's approval. So if you convert, you take that risk and you convert, and then you go to the FDA and they say no to you, the milestone's not payable. So then you restart your phase 3, or I'm sorry, until you go later and get that drug approval, and then it acts as a catch-up. We found that aligned our incentives much better. So that's a one other example of where the contract really plays a critical role in aligning the incentives. Cognizant of time here, let me just double check myself. I want to pause and just make sure I'm hitting all the high points. Talk about license as a property right. The last economic point I'll make, and then I'll and conclude my talk and open it for questions or leave it to Liza, is in profit and loss sharing. Profit and loss sharing is sort of a mechanic that we often use in contracts, again, to align incentives in lieu of royalties. It can be much wealthier or richer for biopharmas to have a profit and loss share, but it is fraught with disincentives as well and complications that really need to be thought through. Profit and loss sharing at a basic level is just that the parties share in some negotiated percentage the profits of the drug and the losses include all the expenses that it took to develop that drug. Your governance structure really needs to be honed and really needs to be negotiated hand in hand with that profit and loss structure, because the decision-making rights critical so to keep the parties aligned, because they can quickly become unaligned if one party wants to do X and the other party disagrees, yet they have to be on the hook for that. An example is you have a license in collaboration where they're co-developing, but the co-development is structured where the more expert party is really doing the bolus of the developing, and the smaller company is doing a smaller portion of it. The company that is more expert might want to amend the development plan and add a handful of new trials, which would add costs to the smaller company, and they may object to that. They may ask for some sort of cap on their expenses in the contract in order to protect their downside, because they've got limited budgets. And that's a reasonable position, but it often can lead to disincentives in the parties. If I am a big pharmaceutical company and I know that anything I propose could be avoided or vetoed because of a cost cap, I'm going to be disincentivized in changing circumstances to say add a new arm to a study that looks at a combination trial, for instance, because my partner doesn't want to pay for the combination trial. What we find often it is a negotiated solution there is to defer the costs of those until we get to a marketable product, and then it's some sort of catch up with a premium for allowing the counterparty to sort of skirt the costs at the real time. So I'll leave it there. I hope that this was helpful to provide some real world experience and some of these really intricate and detailed collaborations. They are highly, highly bespoke. There's no perfection in any of them. There's no.
Thank you so much. Liza, you can unmute yourself and,
All right, I'm gonna, just let me know if you can see my slides. Can you see my,
I see a black screen, but it's probably gonna, yeah,
Here it is.
yeah.
all right, let me just slide. Okay, well, first of all, I am so sad that I haven't been able to be there with you in person today, but I've really enjoyed the conversation. And actually, I've been busy rewriting my talk because a lot of the ideas have been kind of covered and more. So, so thank you for including me, and thank you for letting me to participate, even though I can't be there. So I just want to start with kind of my punchline and what's kind of driving my current project, and then I'll give some context. So my kind of current project, and in particular, sort of my delving into the history of the ARPA models and also looking at ARPA-H, starts with a concern about an increasing disconnect between how kind of the US public and policymakers see the role of government and what we actually are expecting and actually require government to do in the realm of R&D. And this is true in biotech, it's true in AI, it's true in other areas as well. That we need them to do in order to remain technologically competitive, in order to have a dynamic, equitable economy, et cetera. And this disconnect is, I think, resulting in an imbalance in our market structures and the mechanisms that we rely upon to shape them, in particular, the way that we need public-private R&D contracts to work. So that's kind of the motivation. And I look at ARPA-H because I think that, just like some of the other models, but this one in particular, that there's a lot of opportunity for change and for a dynamic way of seeing public-private partnerships. And I think of contracts in this context as really sort of the underlying design of the incentive structures that make these partnerships work in a way that can achieve both public and private goals. So that kind of frames, in terms of sort of how I've come at thinking about this. I started in graduate school looking at contract theory, and sort of the rich literature on contracting for innovation, on different sort of private mechanisms for dealing with things like opportunism. Then I worked for 10 years in tech transfer and in licensing. So at the sort of sitting in the middle of universities and startup companies and large pharmaceutical companies mostly, but also high tech. And so that's where all the things that you've been talking about today really resonated. Things like that it matters what your law firm culture is like in terms of what you draft as your license, in terms of sometimes the contract really matters, sometimes it doesn't, and you have to look to context, and also to the individuals involved. I guess I was surprised in practice that it really matters who the people are. It's not just all kind of economics and rational decision making, or even sometimes it's not any of that, depending on the context. So I greatly appreciate all the discussions. So in thinking about R&D contracting between public and private sectors as industrial policy, and I think that's never been so important. Right, current changes in the law leave us really heavily relying on private ordering, like these types of contracting, to achieve public objectives. And in particular, as we have financialized industry, we require sources of patient risk-taking capital that are really evaporating, in my view. Bill Lozanic, for example, has done a lot of work kind of showing some of those pressures. And so we need to get these contracts, right. I want to talk in particular about the role that contracts have to play in supporting public-private partnerships in health innovation. And that's in part why I look at ARPA-H, although I also think it's a really kind of dynamic opportunity for contracting. To frame this discussion, I think it's interesting to think of why to kind of contrast the public and private approaches to kind of mission-driven, what Marion Mazzucato and others call kind of mission-driven innovation on the one hand, and kind of profit-driven innovation on the other. And so I thought this was sort of an interesting contrast. So on the one hand, we have this sort of discussion of going to the moon, and John F. Kennedy giving this sort of now famous speech of, we're going to go to the moon. It's going to be hard. It's going to be expensive. We have to throw everything at it. We're taking a huge risk, and we're going to do it for the public good. And there's this sort of this interesting contrast with a discussion. So Jeff Bezos went on a sort of he didn't go to the moon, but he went on sort of a space ride. And then the way in which he, before and after, was thinking about that process. So before, he says, I want to go on this flight because it's the thing I've wanted to do all my life. It's a big deal for me. And he indeed has, since high school, been thinking about going to space. When he, and then he says, when afterwards, when it comes to space, I see it as my job. I'm building an infrastructure the hard way. He has this vision of building kind of a highway to space. And he talks about it as using his resources to put in place this heavy lifting infrastructure, kind of neglecting the fact that he's resting on significant public infrastructure to do that. So it's sort of this framing of the private role in a very particular way. He does at the end thank the Amazon employees and customers for paying for his ride, which was also a sort of an interesting way of, when we think about the private sector, we're thinking in particular about some of these large players, and often sort of the highly compensated executives of those large companies as driving a lot of these decision making. So sort of kind of with that perspective in mind, I want to think about the way in which we think about the role of government in public-private contracts. And I draw here for the next couple of slides, and indeed in a lot of my work, from the work of Marion Mazzucato. And if you haven't taken a look at her work, I really highly recommend it. I know some others have already mentioned some of it. But so she makes this point of that we have a narrative that we tell ourselves about the role of government as being big, monolithic, not dynamic, not risk-taking, and their job is to facilitate private sector investment, right? That they're supposed to address market failures and put in place opportunities for the exciting, dynamic private sector to take on risks. In reality, that really hasn't been the way in which the kind of science and technology policy and some of the biggest breakthroughs have emerged. It's really been a partnership largely driven by a risk-taking government actor. And in particular, right, we don't have a single government entity. We have a decentralized network. We have states, federal government, we have different agencies, and they all have their strengths and their weaknesses. And they're operating in tandem with very different players in the private sector and civil society as well. But when we look at how much of the scholarship talks about public-private contracts, we lose that nuance. And if you look at some of the legislative history leading up to things like the Bayh-Dole Act, right, there's a lot of discussion about why we needed the Bayh-Dole Act as a way of addressing private sector concerns about being contaminated by federal funding. And this idea that we needed, that everything was languishing in federal labs. Not to say that there wasn't some truth to that, but it's the sort of the narrative that really has dominated how we think about government contracting. So in Mazzucato's work and in her, she's in a variety of different ways, she's really tried to unpack this, sort of really attack this narrative and suggest how we need to think about the public and private partnerships that we need to support innovation. And she makes the point, which I think is important when we think about contracts as design, that markets are outcomes of how we structure our activities. And so when we are contracting, particularly with these large sort of projects like going into space or developing the internet or what have you, that that the government is co-creating, and this is drawn from her work, but the contracts are in a sense part of market design and should be thought about that in particular when it involves kind of government contracting. Once we start to think about public-private partnerships as kind of co-creating markets, then we should be demanding more from those contracts. Right, so in thinking about, right, sort of what I'm particularly focused on, so I think that Mazzucato's work and others, they provide an amazing way of reconceptualizing how public-private partnerships should work. What still needs some work, right, because they can't do everything at once, is how do you do it? How do you implement it? What does that mean in terms of the incentives, and in particular, the public sector incentives, right? And so Lisa Bernstein earlier talked about how, right, contracts, entities work through people, and right within institutions and with different mandates. And so a lot of my early work has looked in particular with patents on how do patents create tensions with sort of open sharing and open source sharing and private innovation models. Well, also you have this tension between public and private. How do you structure these contracts in ways that deal with that tension always between competing interests, both at the individual level and also more broadly. And so that's sort of the bigger picture. In what I'm doing now is really going into the history of how contracting has evolved over time, in part to educate myself. There's a lot I didn't know about science and technology policy. But I think we're sort of all familiar with the narrative, right, of sort of the post-World War II, or indeed during World War II, a change in the role of government in science and technology policy, the amount of federal investment into that policy. The early model was one in which, and it's sort of most, I think, well-known, talked about in the sort of science, the endless frontier, but this idea of universities and maybe government labs sort of being funded to produce basic science that then will be sort of transferred to the private sector to be developed. And that model has persisted, although it's changed in various ways over time. And there's been a structure developed. And so early, right, the conversation this morning talked about the federal acquisition system, right? Some say it's cumbersome, some say it's protective. I think it's probably both. But it's sort of a system for managing what is sort of invariably conflicts of interest, concerns with capture, and also just transparency and accountability of public money in this process. So the origins, right, and don't worry, I'm not going to go into the history. I'll just really just talk about a few points. So, right, the Advanced Research Project Agency model, the idea was, let's do something different. Government needs to be able to move in a more flexible, nimble way. The first, and the impetus for the first, which was the DARPA model, was largely in response to a technological surprise. So the Russians launched Sputnik, and to the surprise of the American government, and that was sort of a concern that we're going to, a technological surprise, that we might lose our technological superiority. We might, and that also raises national security concerns. Many of the public-private contracts that involve large projects tend to be motivated by concern about technological competitiveness / national security, and I think that remains largely true. Right, so in response to that, they create DARPA, the Defense Advanced Research Project Agency, and sort of the hallmark of that is a model in which you have, and I'm sure most of you probably know how it works, so I won't spend much time, but the crux of it is program managers come in for short-term limited periods. They take risks. They have a portfolio of projects with a mission. The contracts are designed, as Professor Jennejohn talked about earlier, they're designed in a way that you can exit early. They have flexibility in how those contracts are structured. They use things like Other Transactions Authority, which was first introduced at this time, I think, in NASA. Right, so you get these contract tools that are created for these nimble opportunities for public-private partnerships to achieve these big mission-driven goals, and they develop this structure for working. Now with DARPA, they didn't really have to worry about the downstream customer because the customer was the government, right? Largely the Department of Defense, and you eventually get dual use technologies and issues, but the sort of much later, and we're now passing through by Dole and the Stevenson-Wadler Act and all sorts of different ways in which the landscape of contracting for R&D has sort of changed, we get the second ARPA, ARPA-E, and that was largely in response to kind of concerns about energy competitiveness. There's a National Academies report which highlighted these concerns. It was created in 2007, funded in 2009, again with this model of bringing in program managers to take big risks, creating a culture in which government can fail, and trying to get sort of a variety of different sort of ways of addressing large kind of problems, and then getting it into the market. So the one I look at, and I know time is passing, so there's a lot to say, but I'm just going to say a few things about ARPA-H. It's relatively new. It was created a few years ago to address right, sort of to really try and get at some of the breakthroughs we need in healthcare. And it's interesting in this context because unlike, let's say, DARPA, the original sort of model, here there's not a customer there's not a guaranteed customer at the end. So the model again is short term. You come in, you're a program manager, you have I think sort of 3 or 6 year terms, maximum of 6 years, and then you move on. You start a portfolio of projects aimed at addressing a sort of a broad mission. But right from the beginning, you're supposed to figure out and work with the investigator or the company, whoever the sort of the project team, to figure out how they're going to fund it. Because it's not a continual funding model. And so right from the beginning, you're thinking about your goal is to get this breakthrough that will reach the market in an accessible, affordable, and socially beneficial way. And so they've developed an infrastructure around that to try and address this sort of valley of death in what I think is a very innovative way. My concern is that they're not fixing the market in which they are going to then put this technology into. I think there's a lot of literature now that kind of makes it evidence that there's a lot of brokenness in some of our healthcare markets. And so if your goal is to get accessible, publicly, sort of socially valuable innovation that will be reaching the markets in an affordable way, you have to pay attention to the market in which you're putting it through. And what I'm working on now is like, so what does that mean for the contracts you sign at day one? How are you thinking about who the residual claimant is of your intellectual property? How are you thinking about conditionality, right? These are not grants. These mostly are other transactions or they have a few other types of contracts, but they're not grants. How do you build conditionality? What is the role of government, not just in governing the early project design, but downstream? And in doing that, we need to be thinking about that also in terms of building public capacity, right? Because public-private partnerships require vibrancy on both sides. And one of the challenges we have right now is the public capacity to monitor, to negotiate, to understand the technology, and to be a partner in these projects. And so that's really, I think, where I'm gonna stop. There's a lot to say, but I think that many of the people in the symposium are already saying it or have said it. So my work will be just to do some more reading. Thanks very much.
Thank you so much. So I'd love to open it up to questions from the audience.
Can I have a question for Peter? Am I allowed? Do I count as audience?
Of course.
Do you want to go first, Liza?
No. So I would just, so Peter, not that we will have a next pandemic, but let's say we do, like if you could pick 2 changes in our current tech transfer kind of process, or just even one change, like where would you start, right? Because we know it didn't work well. What are some things we should be thinking about trying to do in preparation for the next one?
Sure. So, one item I would prioritize, this actually goes to a question I asked earlier of Matt, is foregrounding technical knowledge sharing, right? So we spent a lot of money providing billions of dollars to the likes of, Pfizer and Moderna. And, we got, again, something very valuable in return, just COVID-19 vaccines, but they were able to retain a significant amount of the know-how and the knowledge that actually manufacture these vaccines as basically proprietary information. And so I would like to see us leverage the considerable public consideration that we provide to these companies to, and we can write this in the contracts, to force them to, if not publicly disclose, and obviously there are reasons why they wouldn't want to do this, but perhaps they could agree to limited disclosures of this technical information, particularly to global manufacturers, which could have ramped up production of vaccines much faster. So I think prioritizing knowledge sharing would be a good place to start.
So that's fascinating. John Murray, I wanted to ask you how frequently milestones are adjusted or royalties are adjusted. How often does that, do adjustments have to be made to align incentives? Is this something that comes up frequently?
Not often with regard to royalties. Unless something has really gone astray in the partnership. Milestones, yes, can be adjusted, and sometimes it's to realign incentives, but other times it might be just to address new developments in the program. Or in the context of a particular structure that I talked about, an option deal, where one party is taking an option to license, but they're really leaving the program with the licensor until they exercise that option. And yet, in the midst of that, you've got changing circumstances. The science is going in a direction that was unpredictable. You need to readjust the development program and that R&D plan. And I think you talked to others in the industry that describe these R&D plans as 100-page documents, and they are. They're incredibly detailed plans, but often those get changed. Often milestones sort of hang together with the development plan, and as the development plan changes, you sort of renegotiate what those milestones are. I think the readjusting or renegotiating milestones, I wouldn't say happen universally by any stretch, but it's more often than you would adjust.
So is the purpose of the adjustment to keep the interests of the parties aligned? Say if there's give an example of, there's a new development.
Yeah.
Okay. So things have to go in a different direction.
Yeah.
And the innovator may feel that maybe they're not being compensated if they're required to do new things or something.
Yeah.
So that's where the adjustment would come in.
Right. Yeah, that's exactly right. I mean, there are absolutely circumstances where, because of new developments in the science and the technology, certain milestones, I mean, if you've got broad milestones, like if you initiate phase 3, those don't become moot, right? They just don't. But you absolutely can have milestones that are built around, particularly in discovery stage deals, that are built around identifying a particular chemical structure that looks a certain way, or that has certain behaviors. Or in a platform deal, life science, there's types of deals that are platform deals, and that's where you're really sort of building the plane as you're flying it. Because when you do a platform, when I say platform, it's, somebody has, I think somebody described, maybe it was you, some firm had a machine for identifying cells. That's sort of a platform. Or somebody has a platform that can screen compounds as a research tool to identify viable compounds. And so maybe the milestone is, we'll pay you X dollars if after, a certain number of screens you run, we have, a dozen compounds that have a certain characteristic to them. You get into the science, you do the science, and it doesn't look like that's going to happen, or the structure or the characteristics are looking different. You can moot your milestone, or you need to renegotiate what that milestone becomes or is payable for. There's also another, so it aligns incentives, but there also can be a very, very practical component to readjusting your milestones, just funding your partner. Your partner is a small biotech that is working on a shoestring. So they're funding themselves by, the upfront payment you've given them for the license. They're funding themselves by the milestone payments, and then their only other source of money coming in the door is from capital that they raise from venture capital partners or, what have you, or IPOing. Because science fails more often than it succeeds in this industry, if the parties want to continue the partnership because there's some portion that's promising, you kind of need to put some more money in the coffer to keep it going and to readjust your milestones as you renegotiate.
That's helpful.
Do we have one last question? Because I think we're,
Oh,
what?
one last question. If you all had like, a chance to improve something in the public-private partnership model, right? As much as you see it, to make it more efficient or more successful or to encourage it, what would it be? What would be that one thing that you would change or perhaps not? Yeah, Liza.
Oh, so I think I would change, right? That I would borrow more from the private collaboration model and treat the government more like a private collaborator in terms of expecting to share not just in the cost, but also in the governance and the returns.
Thank you.
So just very quick, I would just urge the government to strike better bargains and to leverage the considerable capital it provides to private entities to actually, get certain rights and opportunities that serve the public interest. So we talked a bit about, information disclosure. Bible is another example. So, we're granting, millions of dollars to researchers, and they're performing great research and getting patents and inventions, but margin rights are never exercised, and so there's kind of a missed opportunity there.
But one thing we might say is if we think about relational contracts and ask, why is that true? No, it's because of the future career opportunities, right? The government officials help to get. So how do we fix that?
In the revolving door?
Exactly, yeah.
Yes.
Yeah.
And if I were to propose a change or something that could aid the public-private, actually better would just simply be open communication, a better communication, particularly the impacts of, public regulation on certain industries. And I don't think the biopharma industry is an exception here, but, one thing that Professor Jennejohn mentioned in his is just vulnerabilities in supply chains. And every industry has certain vulnerabilities. Mine is no exception, and the Biosecure Act was one that exposed a very now prominent vulnerability that large, almost universally almost, were using WuXi as a CDMO or a CRO, and the federal government has shut that down, proposed legislation to shut that down because they suspect that WuXi has shared personal data with the Chinese government. WuXi may not have done that. I don't know. I don't know the details of what they did, but there's lots of actions that WuXi and there's business that WuXi does that is not harmful, and the industry relies on. And that act left us scrambling. And I think that there maybe I think there's good intention there behind the government and why they're doing it, but a little better communication of unintended consequences could improve how we go about, implementing things.
Thank you, everyone. We have closing remarks, right? Or no?
Well, really, we don't have any. I think we just want to get together and say goodbye to each other before we take off. Does that make sense? Except to say that the whole conference was wonderful. And the kind of discussion that went on here is just really inspiring. I think you gave us all a lot to think about. I think we'll get a recording of this. So you can kind of if there's things you want to hear again, or, and then we'll look forward to the publication of some of the papers in the CWRU Symposium. And there was a reference on a slide earlier to a paper that was in the last LEET Symposium. So anyway, it's great. So anyway, I just want to thank everyone for coming, making the effort to get here, and to converse with your colleagues and to share ideas. And certainly we have a lot more to read from the things that were mentioned on the slides.
Absolutely. And
anyway.
thank you to Professor Kostuski for bringing us together and organizing everything.